Welcome, everybody, to the Cathleen Scott Podcast. I'm here joined today with my business partner, Gabe Roberts of the Scott Law Team. And we're going to be talking about a new bill that is currently on the governor's desk. It is House Bill 1219, and it is an expansion of the current law on non-competes and other types of restrictive covenants. We're going to talk about things like non-competes, non-solicits, how they're enforceable, the standards of proof, the lack of due process, and some other challenges with the way the new law is currently written. We're going to get into some technical changes if the bill does become law, and we look forward to keeping you updated on it.
Right. Could be
What
signed.
if it doesn't get signed?
Could be vetoed, or if the governor does neither, then it seems like it becomes law without the governor's signature on the effective date, which the effective date is July 1st of this year. So it seems like, and if we're doing our calculations right, which never trust a lawyer to do math, that's what we have paralegals for, right? So if we're doing our calculations right, it's Friday, then May 9th would be the deadline for the governor to take action. And if he doesn't take action, then it seems like on July 1st, this bill will go into effect.
And so we've heard a lot of chatter and noise from the FTC, from the NLRB, from lawyers about the future of restrictive covenants or non-competes. So Florida has a bill, 542.335 currently, that allows for restrictive covenants. Let me just set the framework, and then we can talk about how this bill kind of changes that. So a little background: in order for an employer to have an enforceable non-compete, they need something very special. They need a legitimate business interest, or an LBI. And that's something that they have given to the employee: confidential information, client relationships, trademarks, trade secrets, extensive training, goodwill, something that's something the employee didn't walk into the workforce with, that they learned that's a higher level that could support the reasons why they need protection from an employee leaving and going out and competing. Under the current bill, there are limitations on how long a restriction is last, or I should say rebuttable presumptions on how long restrictions can last. In general, it's 2 years after an employee leaves. So Gabe, tell us, what is this new bill? Assuming it does go into law, it would be July 1. What would it change?
Well, it wouldn't change as much as it would add, right? So that 542.335 structure of the law that's currently in place, it's not going anywhere, right? This is in addition to that, creating essentially these separate special types of contractual provisions that are on top of that, right? But I think the historic background of how we get to this bill is helpful as well to talk about it, right? You were talking about Florida has a law in place that currently relates to restrictive covenants like non-competes, non-solicits, non-disclosures, et cetera. And then there's been a lot of attention, like you said, paid to this with the FTC, the NLRB. The biggest thing last year, 2024, the FTC had issued a rule that would have banned non-competes nationwide. That rule didn't go into place because a couple judges issued orders essentially banning its implementation, and then there was a change in administration, and the new administration, it looks like, is not going to continue with the prior administration's rule. But then we still have something like this bill here that I feel like it's a direct response to the FTC rule, where if you look at the findings the FTC made in their proposed rule, they did a lot of research into various states and industries and found that here is what these non-competes actually do to the individual workers. And one of the things that jumped out to me reading the FTC's rule was they said there's alternatives you can do here, right? You can have non-solicits, you can have non-disclosures, you can have other ways to protect your information that states like, for example, California or New York, which don't have as strong of non-competes, but are some of the biggest states when you talk about economy, that they use instead of non-competes. And the FTC said, yeah, there's alternatives. And then you look at House Bill 12.
There's sort of an umbrella of restrictions that probably we should mention. That one example might be confidentiality, both during and after your employment, maintaining employers' confidentiality. Another example might be not soliciting customers or employees. That's a non-solicit. Don't disclose our confidential information or confidential details. That's the NDA. And then the big one, the kind of like the most restrictive, is the true non-compete, where you just don't work competitively.
Yeah, exactly. And then so it jumped out to me reading House Bill 1219 that the Florida legislature has made its own findings in there, and their findings are the exact opposite. I mean, they say directly, we actually don't think there are any reasonable alternatives. We think non-competes are the only thing you can do to protect your confidential information and customer relationships.
Let's just pause on that for a moment. Let that sink in for a minute. The Florida legislature and this pro-business kind of administration is saying we can't live without non-competes. We're going to double down on them, essentially.
Right. Yeah, we're going to double down on them. And also, go against what's sort of the real historical background here in Florida, which is that, constitutionally, right, that we have this prohibition on restraints on trade, and we our legislator has a prohibition on a restraint on trade, which is a fancy way of saying a non-compete, right? A non-compete's a restraint on trade. And the law we have now is, in theory, supposed to be an exception to that, where it says, notwithstanding the prohibition on restraints on trade, they can be legal in this specific situation. And then House Bill 1219 is like, no, we're not even going to do that. We're just going to say that this is not an exception. It's the rule that in these situations, these things are going to always be legal and enforceable.
But I thought, if I remembered from the beginning of the statute that talks about restraints on trade, right? Like, can't have a monopoly, can't control all competition. I thought there was supposed to be a balancing test between an employee's right to work and earn a living and an employer's right to protect its confidential information. Does this bill go beyond that balancing test?
That's how it appears, right? I mean, we'll see what happens in practice, and you and I know this from practicing in this area and actually litigating these cases. In practice, it's not like 542-335 is also doing a good job of the balancing test, right? I mean, we see cases all the time where what's supposed to be a balance of, okay, restraints on trade are unlawful in the state of Florida. So we're supposed to be starting from the baseline of this non-compete's unlawful, right? That's the baseline. However, if you, the employer, can prove that you have this legitimate business interest and you can plead and prove it and show that it's, reasonably necessary to enforce that business interest, then okay, you can enforce it. You and I know in practice, judges don't do that, right? They say, well, there's a contract and you signed it, or they don't require somebody to plead and prove all the business interests, or they don't actually do the business interest analysis. There's a lot of things in practice where, I don't know. I look at this.
I feel like I've had a very successful track record in not having my clients be enjoined, and I know you have as well. So
yes, but we can both think of a couple specific examples of cases where we're looking at a situation where, like, Your Honor, there's a law that says they have to do this, and they didn't do it, and we probably both have had judges that say, well, yeah, but your client signed that contract, didn't they, Mr. Roberts? And it's like, okay, but that's not what matters. But anyways, I bring that up because to me, like, House Bill 1219, it's a solution in search of a problem, right? Florida does not have an issue right now enforcing non-competes. But if you read the language of this bill, it would give you the impression that there's some sort of, lawless rebel state going on where everybody is trying to steal your customers, steal your confidential information, and open businesses. And I don't know if you see this, but in my experience, I don't see that happening.
Right. And I think it's interesting because usually the maximum presumption of reasonableness for how long a non-compete can last for an employee, different for someone selling a business, of course, is 2 years. This bill increases that to 4 years, if I'm reading that correctly. And most judges who have looked at that issue have been like, 2 years is a long time for someone to sit out and not work and not get paid. You might work for an employer for 6 months, and then now you can't work for 2 years, but under the new bill, 4 years. That's extraordinary.
Yeah, it changes it from, up to 2 years being, or beyond 2 years previously would have been unreasonable or presumptively unreasonable, to now it can be up to 4 years is how long one of these, what they're calling a covered non-compete agreement. And we should probably take a step back and sort of talk about what these provisions are, right? We have this covered garden leave agreement and a covered non-compete agreement is what they're called. And they are sort of uniquely defined, right? This is not just a standard, a contract that says you can't compete, right? There's some special or specific requirements involved there.
Yeah, I was very stunned by, so in the current statute, under the current statute, an employer has to come to the court and say, this is the confidential information that I'm trying to protect. Here are the steps that we've taken to keep it confidential, passwords, we put it in a locked box, we put it under my bed at night when I go to sleep, whatever the craziness is that you do to protect your confidential information. You have to prove that, one, that it is confidential, and two, that you've protected it. I think, and then for it to be a trade secret, it has to, derive an economic benefit. But just generally speaking, that did not seem to make its way into this new bill. In other words, if I'm reading it correctly, it feels like the employer just gets to say, poof, confidential, and by magic, whatever they say is confidential is in fact confidential.
Yeah, that's how it reads, right? I mean, you made a comment earlier about, judges are used to looking at 2 years and saying, I don't know, it's a long time. And now we're kind of saying, well, judge, you got to look up to 4 years. I mean, there's a lot of things in this bill that I think judges might not like because it takes away their discretion and the proof component that you're talking about gets at that, right? Where if you are a company and you have a properly covered non-compete agreement, right? You gave your employee the right amount of notice and they had 7 days to review it with an attorney before they signed it. The employee meets the income threshold, which I'm sure we'll talk about more in a second, right? If you have that covered non-compete agreement and your employee leaves and you think they're violating it, right? You don't have to know that or prove it. You just think they went to go work for the company that's competing with you. If you file a lawsuit and you ask a judge for a court order, the judge is required to issue that court order, no questions asked, right? They have to just say, okay, yeah, you asked me for an order that says this person's violating their agreement and prohibiting them from doing what you say they're doing. You don't have to prove anything to me. I'm required to give you that order. And then the burden is on the employee to come to the court for the first time. Now they're out of work and say, hey, judge, I just lost my job because you issued this court order. I guess I'll somehow pay for an attorney and then have my attorney present clear and convincing evidence that actually I'm not competing.
So you said a lot there. I want to break that down. So in the traditional setting, pre-House Bill 1219, an employer would have to prove and establish harm, would have to plead and prove to be entitled to an injunction. If I'm hearing you correctly, this bill makes it automatic and almost deprives the employee of any kind of due process to stop the issuing of that injunction from happening.
Right. And not only the employee, who at least they signed the contract, it also deprives the future employer from any due process. And they didn't even sign this contract. I mean,
so company ABC hires Gabe Roberts to work with them. Gabe signed a non-compete. Employer, without having to meet any evidentiary standards, without having to put anything in an affidavit, without having to take your deposition or understand the facts and circumstances, can go without notice, I understand in the bill, can actually go to the court and say, stop Gabe from working, and order both Gabe and ABC company from hiring him and keeping him employed automatically. And look, we don't, the timing of this, we don't know how it'll work because look, it's not a law yet. July 1st is when it becomes effective. I'm sure we'll see some lawsuits on July 2nd or July 8th because they need to give them 7 days of notice to sign a covered agreement. But we'll see what happens and what judges do with this, because what the law says now is upon application, the court must issue an injunction, right? And so what does upon application mean? Does that mean you file a complaint? Does that mean you did a motion for temporary injunction? When it says the court must, does the court need to have a hearing? Is there a 5-minute motion calendar hearing in the morning? Or is it a complaint gets filed and you file your motion for temporary injunction and the judge sees that motion and issues the order? I mean, we don't know practically how judges or courts. But let's put it into context for people who are listening, who may not be lawyers, right? If you are a victim of domestic violence or you suffer a battery, it is normal to go to the court and ask for your attacker to be kept away from you. In that scenario, the attacker has a right to notice, has an opportunity to be heard, can come into the courtroom and say, I didn't do this, or this is what happened, there's mitigating circumstances, or it's taken out of context, whatever, but they get an opportunity to say their piece. It's called due process, right? Before they are restrained from contacting who might be the mother of their child or the father of their child. I mean, whatever the circumstances. But now in the employment context, we're going to say no. We're going to put a bill for the governor's signature that says you don't need to follow that due process. You're just going to be, if you're accused, the employer signs something saying that you're doing it, there's going to be an automatic injunction. As it's written now, without any further enabling legislation, without any further detail. I use the word extraordinary, but that is really extraordinary.
Yeah, I mean, there's been a lot of talk in the news with current events recently about who gets due process in this country, and what this law does is it says that in addition to whoever the president says doesn't get due process, guess what? Yeah, employees, you also don't get due process, right? If you leave your former job and they think you're competing, you don't get due process. They just get a court order that tells you got to sit out and not work.
And I don't think I'm giving anything away. Often these non-compete cases get defended because the employee is able to say, I didn't learn that from the employer. I knew about this either before I worked for the employer or I learned it on my own. A classic example of that is what vendors a company might use, right? Well, let's say you're a sales company and you use vendors. And where do you find your vendors? You go to a trade show. And I have defended numerous non-compete cases based on the fact that these vendors are not a secret. They're out there putting up trade shows and saying who they are and what their pricing structure is for anyone who will buy from them. So that's not confidential information. Under this law, confidential information seems to be whatever the employer says it is, even maybe if it's accessible by another means.
Yeah, I mean, there's a lot of weird things in this law that sort of change how how we've always done things legally from a procedural standpoint, right? And one that is I haven't seen getting much attention is the idea of confidential information. And there's a provision in the House bill that says you're required to file. So let's talk about this injunction process, how you fight it, right? So your former employer goes to court, and the judge issues a court order that says, "Hey, you can't work anymore." You can get that court order set aside by proving by clear and convincing evidence a series of things, such as you're actually not competing, or you're not working, or they didn't pay you appropriately when you worked there, or things like that, right? But when you're submitting that information to establish that clear and convincing evidence, you are required to file under seal any information which the former employer has deemed confidential. But you're doing this without knowing what they've deemed confidential, right? Like, we as the attorneys, right, we're representing somebody who has an injunction against them, who needs to get it set aside. We're going to file a response and an affidavit from our client that says, "Hey, here's all the reasons why my client wasn't actually paid appropriately during their employment, and so therefore this injunction should be set aside." And maybe we include with that, their offer letter that sets their pay rate and their pay stubs and whatever else it is. If their employer, for whatever reason, has decided that they think the offer letter or their pay stubs or those pay stubs are confidential, and we didn't file those under seal, well, now we're in trouble because we just violated the law by not filing what the employer has deemed confidential without us knowing under seal.
It seems onerous to the employee, and you use language in there clear and convincing. I want to make sure we, explain in a traditional civil case, the person who brings the lawsuit, or the plaintiff, typically has a burden. We call it the preponderance of evidence. Everyone's done the closing argument example. They hold their hands up and they say, you have to tip it just ever so slightly. And that's what it means to win a case by preponderance of evidence. So an employee that's being sued for non-compete, unlike every other type of civil case that I'm aware of, where it's a preponderance of evidence standard, they have to disprove they're violating by showing a much higher threshold by clear and convincing evidence. That also is a huge change and a huge shift. Typically, we only see clear and convincing evidence in situations where there's like someone seeking punitive damages against another party. So I just wanted to mention that.
Yeah, and you're gonna have to get a hearing date to show that, right? So again, we don't know practically what this is going to look like, but the way we're reading it is employer files a lawsuit, asks for injunction, court grants it, no questions asked, right? And that happens without a hearing because it's upon application. You are the employee or the new employer, and this injunction was just levied against you, and you're trying to get it set aside, and you need to do that by proving these various things by clear and convincing evidence. That requires an evidentiary hearing, and we know this when we're trying to schedule an evidentiary hearing with a judge. I mean,
months.
Yeah, I mean, we had a case that went to trial in June, and we couldn't get an evidentiary hearing until the next May. Like that. And I'm not saying that's an extreme example, but it's one of those things where that entire time while you're trying to get an evidentiary hearing in front of the judge to prove by clear and convincing evidence, whether it's a month, 2 months, 3 months, there's a court order that's prohibiting you from working. And so that entire time, the pressure is on the employee to say, you know what, screw it, I'm not going to do it anymore. I'm just going to move on and do something else.
Now, under the old statute, well, soon to be old statute, if this passes, it was clear that the employee could ask for a bond during any period of time that they were sitting out. That is not something I saw clearly set forth in the new statute. Did I miss that, or is it?
It's not set out in there. I mean, I think what we'll probably see happen is, because a lot of stuff regarding injunctions and all that, like, they're governed by other rules of procedure, other laws that relate to things like that, and we'll probably see judges sort of kind of incorporate that into that and say, all right, if you're going to get this injunction, maybe the judge will require them to issue a bond under a separate law. I mean, I don't know. It's probably going to. It'll depend on who the judge is and how they want to say it. I mean, looking at this law by itself in a vacuum, there's nothing in there that requires that. All that requires is an application, which I don't know what that is, but upon application, they get the injunction. So I don't know what application means, if that's a complaint, if that's a motion, if that's, sending an envelope with a bond. I mean, who knows?
It seems like there's a little bit of good news in there if you're a healthcare provider, although I think there's a caveat too. So I feel like is there a carrot and a stick if you're a healthcare provider?
I mean, I think there was an attempt to put a some sort of good news for healthcare practitioners. I mean, we've seen in recent years there's been some effort and attention made to kind of change the scheme of non-competes for healthcare practitioners, right? I mean, we had a few years ago, there was 542-336 was passed, which kind of set out the exception for if you're providing, medical care and you're the only one in your county who's doing it, then there can't be a legitimate business interest prohibiting you from doing things. And so that's something there.
Because maybe people have the right to choose their doctors, and they shouldn't be limited by a doctor having signed a non-compete that precludes an expert surgeon from working.
Right, and we saw, I think it was the last legislative session, there was a representative introduced a bill that would have specifically excluded medical doctors from any non-competes, right?
That seems like a good thing. No?
You would think, right? And so then we look at this bill here, and it looks like there's an attempt to kind of seem like they're doing that. So when we talk about who's covered by this, right, who's a covered employee under this, it's anybody who earns twice the annual mean wage of either the county where the company does business, or if it's an out-of-state company where you, the employee, reside, or if you meet twice the annual income, it does not apply to healthcare practitioners. The new law does not apply to healthcare practitioners. And it's interesting because it says healthcare practitioners as defined by, and it gives you a different statute. And this is kind of the catch-all licensing statute in Florida that basically applies to anybody who does anything medical related. I mean, I looked, it's,
chiropractors, MDs,
from doctors to acupuncturists to massage therapists, right? This is the healthcare practitioner, basically anybody except a veterinarian. If you that are covered by this, would you be exempted? And I don't know. I'm not a legislative expert either. I was not part of these sessions. It seems to me that was probably put in there as sort of an incentive to get the healthcare industry behind this. But the issue is, because this bill does not replace the current statute, it just adds to it. All that means is that if you're a healthcare practitioner, okay, you can't be covered by this new special heightened non-compete requirement, but you're still stuck in the other requirement that still currently exists. So non-competes can still apply to you.
Right. So the bill says the new expansion exempts healthcare providers, but then also says anybody not covered by this act is covered by the previous law.
Right. Yeah.
Yeah.
Which is, it's a different, it's a slightly better law, the current one, right? It's not perfect. And there's a lot of studies out there that have said Florida is one of the worst states in the country for non-competes, even before this new bill. And so even under the old statute, it was not good, but it's,
right.
So you're still covered.
Great if the legislators actually involved an employment lawyer who actually litigates these issues to try to help them draft a bill when they're seeking to make drastic changes? That might be helpful. Okay,
we have lots of. I mean, the state of Florida has many good law schools with professors who are employment law specialists and do research in this area. Maybe include one of them. I don't know.
So it feels like employees are going to have a harder time unwinding a non-compete, a harder time defending against a non-compete. They have a higher burden of proof. There's an automatic injunction. But if they make less than 2 times the mean salary, they don't have to worry about restrictive covenants. What does that mean, 2 times the mean salary?
Yeah, that's interesting because it's defined as basically looking at Federal Bureau of Labor Statistics for the previous previous few months. But you look at Bureau of Labor Statistics and you say, okay, what is the mean salary within your county? And then actually, hold on a second. Sorry, I'm going to actually pull it up while we're talking. That's easier. Okay, so all right, so we're looking at you go to the Bureau of Labor Statistics, and we're talking about somebody who earns a salary that is greater than twice the annual mean wage of the county in this state in which the covered employer has its principal place of business. So that's the first thing. So if the company, the employer, they have an office, their office is in Broward County, if you earn twice the annual mean wage of citizens of Broward County, then you could be covered by this.
What's an example of that? Like, what's the average mean?
I think we looked it up for Palm Beach County because where our office is, and I think it was like 68,000 was the average. So it was going to be somebody who basically earned 130 or higher, or 140 or higher. It was going to be a
year. Yeah. If you make 132,000 or more a year in Palm Beach County, you can be restricted. But if you make less, the law doesn't apply to you. But
right, the new law will not apply.
The new law, but you're still governed by the old one.
Yeah, your non-compete is still enforceable against you under the old law.
And you mentioned, we talked kind of several times about the fact that it's not just a change in terms of how it's going to affect employees who sign restrictions, but also where they go work after they leave. So this seems to be very challenging for if I'm a business and I want to hire employees. There's really no way. It seems like it's much more onerous. I too am going to get sued as a business for hiring employees, and I too am going to be subject to this automatic injunction idea. So doesn't really feel super pro business in that respect. Feels like
No,
it might make it harder.
Yeah, I don't know who this law is pro. It's because it hurts everybody, right? It hurts worker movement, it hurts the labor industry, but it hurts companies because now if you're somebody and you're hiring anybody, and you're gonna want to know, do you have a covered non-compete? But that's a dangerous question to ask somebody, right? Because if you ask somebody if they have this covered non-compete right now, if they say yes, and then you hire them anyways, now you knew about the contractual restrictions, and so you're potentially setting yourself up for other claims, that we see sometimes, and that's a problem. But the other thing is, because of the way this new bill would act, if the injunction is automatic against the employee and the new employer, and so if I hire somebody and they have one of these covered non-competes, without me even knowing it, I might get a court order that tells me, hey, don't hire this person. And if I don't want to pay an attorney to go get that set aside, then I can't hire the person I want to hire. So it hurts companies, it hurts employees. I don't know.
And the lawyer gets their fees paid too. There's an attorney fee provision as well. So it's a very expensive type of litigation all the way around.
Sure. Yeah. I guess, like most laws in Florida, it's, drafted by lawyers for lawyers. So we get our fees. I guess maybe there's something there, but that's, to me, if we're making legislation so lawyers can get their fees, then we're not actually doing anything to help anybody.
Well, we will keep our listeners posted on the new changes. We should update everybody in a few days to see if the governor, hopefully, maybe the governor will listen to our podcast and recognize that there are some blind spots here that need to be filled in. And just in case anyone's listening, there are several blind spots that need to be filled in.
Yeah, just please don't have Governor DeSantis look up any other cases we filed recently.
Yeah, oh my gosh. Then we'll remove that. Okay. Thank you so much for tuning in to the Cathleen Scott Podcast. We hope this was fun and informative. We'll catch you on the next one. You can find us online at scottlawteam.com or floridalaborlawyer.com. Thank you for joining.